Sometimes, justice isn't about what happens inside the courtroom, but about what the cameras don't show. In a quiet Florida town, a man named Calvin Riley Sr. was pulled over on suspicion of driving under the influence. A simple DUI stop, or so it seemed. But what started as a routine arrest would soon unravel into one of the most controversial and unsettling cases in recent memory. A story that made many question not only the law, but the people sworn to uphold it. This is the case of Calvin Riley Sr.
With driving under the influence cases, with investigations. And that second officer, her name is Officer Margaret Muth. You'll learn that Officer Margaret Muth actually worked over in Oregon for a while, and she handled DUI cases there before she came to TPD. And you'll also learn that the sole intent of why Officer Muth came to the scene is to help detect signs of impairment, and nothing more. So now let's talk about what happened when Officer Muth gets to the scene. You're going to learn that Officer Muth came to the scene, and Officer Oliver indicated, "I'm not sure. There might be a smell, there might not." She's going to say, "Hey, can you help me? Can you help me do the investigation so I can watch, so I can learn from you?" Miss Officer Muth says, "Yeah, sure, I'll do that." Decides to walk away from Officer Oliver, goes to approach the defendant on her own. You're going to learn that she makes her own assessment as to whether or not the defendant is impaired. She'll say the same things. She noticed glossy eyes. She noticed slurred speech. More importantly, she's going to tell us something that the defendant didn't tell Officer Oliver. And this is what
burden shifting. Sustained.
You're going to learn that the defendant told Officer Muth two things. First, that he was drinking alcohol. I believe he said that he had 2 beers that night. Number 2, you're going to learn that the defendant told her where he was coming from that night. So, members of the jury, it's as simple as the defendant was at Pockett's Bar and Grill earlier that night. He spent the night there drinking alcohol, and then he decided to get in his car and leave, drive home. At that point, the officers go back. You're going to learn that there was more than just a DUI investigation at that point. That they also decided to pull up their internal program, run a driver's license check on them, just like any other traffic stop that occurs. And when they did that, they noticed that the defendant's license was listed as suspended. That suspension was caused by the lack of insurance he had for his vehicle. His car was not insured, as the laws here in Florida mandate. So when Officer Oliver and Officer Muth see this, you're going to learn that they go and place him under arrest. And that's where the next part starts. You're going to learn that those are the signs of impairment. That's when he's arrested. And then there's an additional investigation. So let's talk about that additional investigation. After the defendant is placed into handcuffs, brought over to the patrol vehicle, there's 2 things that happen. Number 1, a search of his vehicle. And number 2, something called implied consent. So I'm going to take those one by one. The search of the vehicle. The search of the vehicle happened after the defendant was placed under arrest, after the signs of impairment had already been established. When the search of the vehicle occurred, you're going to see every part of the video, every part of the body-worn camera, and exactly what the officers did. You're going to learn that both officers went from one side of the car to see what they could find. And when Officer Oliver was searching, she noticed on the driver's side that there was an alcohol bottle in a pocket. When she noticed this at first, she left it in the car. She didn't do anything with it initially. But you're going to learn that later in the investigation, when Officer Muth was at a completely different part of the scene, talking with the defendant, Officer Oliver made a mistake. I'm going to be honest, she made a mistake. Thinking that TPD policy, the Tallahassee Police Department policy, was that You're supposed to dispose of alcohol. She decided to do that. And let's be clear, you're going to learn in this trial that there is a policy that specifies that. And she's a new officer, so that's what she's trying to do. She's trying to do her best to stay and stick to protocol. So seeing this bottle, she goes to open it, to dump it out, not realizing at the time that it was sealed. She's going to tell you that she didn't realize that and that she made a mistake. Now, after this happens, she dumps it out and puts it back in the vehicle. And that's all that happened. They didn't take it into evidence. It's not something that they necessarily thought was the most crucial piece. The signs of impairment were the biggest piece of evidence in this case. And that's all that happened. So I want to talk about the second part of their investigation that I mentioned, the implied consent. Another thing that we briefly touched on here during jury instruction or jury selection. See, in the state of Florida, when we get a driver's license, or if we agree or even operate on the roadways here, we automatically consent to what's called a breath test. And that's basically where, when law enforcement asks for a lawful sample of your breath, you're supposed to agree to it. At first, that might not sound like a big deal, like, hey, I might want to refuse it, but you're going to learn that it is a big deal. Because in Florida, if you refuse a breath sample of this sort, you automatically lose your driving privileges for an entire year. No driving to work, no going to the movies, no going to the mall.
Your objection has collateral consequences.
Overruled.
As well as in the statement of law.
Just move on from it.
When law enforcement informs the defendant of these consequences of the implied consent, they read him a form telling him that he'll lose his driving license privileges for an entire year. What does he do? He screams, he shouts, he talks over them. You're going to learn today that the defendant's behavior was so belligerent in that moment that they had to call a third officer to the scene.
Objection inflammatory.
Overruled.
When that third officer, who you'll hear from here today, his name is Sergeant Brian Smith, he's going to tell us about what the defendant said in response to the breath test. Because you'll learn that he wasn't asked once, he was asked multiple times. In fact, when Sergeant Smith asked him, hey, if this is just a big misunderstanding, why not just take the breath test? You're going to learn that he still refused.
Objection burden shifting.
Overruled.
Members of the jury, what I'm asking from you in this case is to stick to the facts and look to the facts of the case. The facts will guide you throughout this trial and throughout your deliberations. You are sworn to uphold the law and the law alone. And the facts are simple. He was driving. He admitted to drinking alcohol. He admitted to being at a bar. Notice was sent to him 3 months in a row saying your license is suspended because you don't have insurance. And he still chose to drive despite knowing his license was suspended. He still chose to drive because even though he knew he had drank alcohol. The facts are simple. At the end of today's trial, you're going to hear from all the witnesses who are necessary. You're going to have the opportunity to review evidence and video footage. And at that point, we're confident that you're going to see the truth, that the state has met its burden, that we've proved this case to you beyond a reasonable doubt. Not a mere speculative doubt or forced or imaginary doubt, a reasonable doubt. You will see the truth. And the truth is that the defendant is guilty.
As the courtroom watched, something felt off. The officer's testimony was clear, too clear. And then, that small detail, a bottle, half empty, moved. The defense noticed it, the jury noticed it, and the internet noticed it too. Was it carelessness or manipulation? One single motion, one piece of evidence, suddenly changed everything. What happens when trust begins to crack? When those who serve justice might bend it?
This case involved an officer planting evidence. I'm not going to sugarcoat it. What you are going to see from the officer is shocking. It is egregious. It is outrageous. It is not an innocent mistake. There is literally an officer on camera making evidence where none existed. And I expect all of you will get to see with your own eyes. Officer Kirsten Oliver of the Tallahassee Police Department stopped Mr. Riley for his headlights being out. She claims she smells marijuana. You will hear Mr. Riley protest. He does not smoke marijuana. The claim that she smells marijuana is what lets her search the vehicle. Officers remove Mr. Riley from his car, put him in a patrol car, and then search his vehicle. They, of course, find no marijuana.
On the traffic stop, I noticed a vehicle traveling behind me at a high rate of speed, and then I noticed that their headlights were off.
How fast are we talking about?
I would say faster than the speed limit, which was 45 in that area, so I would say maybe about 10 miles over the speed limit.
Okay. And I just want to be clear for the record, did you have any type of device that was able to ascertain exactly how fast he was going?
No.
Okay. So is it safe to say that that was something based on just your observations?
Objection, leading.
Overruled.
I'll ask the question again. Is it safe to say that your observation was, or your assessment of the speed was based on your observations?
Yes.
Okay. Is that something that you do in other traffic investigations or traffic stops?
Yes.
Okay. When you were at this initial traffic stop, where were you located?
I was at the intersection of South Monroe Street and Magnolia.
Okay. And I'm not sure if you covered this. The vehicle that you saw driving down the road, was there headlights on it?
No, there was not.
Okay. So now that we've talked about this vehicle that you noticed, what's your initial reaction when you see it?
I was kind of shocked. I was like, okay, let me go stop that vehicle because they don't have headlights on and they're driving too fast.
And was it dark out when this happened?
Yes.
Okay, so you said that you wanted to go stop it. Did you stop it in your patrol vehicle?
I did.
Okay. How long did it take you to catch up with the vehicle?
Several seconds, longer than the average stop. It took several streets passing until the vehicle did stop.
Okay. Can you describe to the jury the driving pattern of this vehicle?
Yes. So the vehicle that I saw was traveling without headlights on. It was traveling at a speed above 45. When I got behind it, it was starting to slow down, but it wasn't stopping. My blue lights were on, and the vehicle was kind of swerving in and out, crossing the line into the right-hand lane next to it, and it was, kind of just going in and out of the lanes, the lane it was in, and then the lane next to it.
Okay. So you mentioned that it was swerving into the right-hand lane. When it was swerving into the right-hand lane, was there any vehicle in that lane?
Yes.
Okay. What happened there?
So there was a vehicle, next to it at one point, and they never collided or anything, but it was close to, it concerned me that they were going to hit them.
Now I want to pause for a second. We talked about your DUI training from before you started working with the Tallahassee Police Department. Were you trained to look for specific driving patterns in
Yes.
DUI? I'm sorry, yes.
Yes, I was.
Okay. So what specifically in your training were you told to look for or trained to look for driving patterns?
So with driving patterns, traveling too slow, too fast, not able to maintain their lane that they're originally in, changing lanes, excessively, and just irregular patterns of, not normal driving.
The driving pattern that you saw that evening, was that consistent with the impairment signs you were trained to look for?
Yes.
So now you put your headlights on. Did the vehicle put its blinker on?
The blinker was on, I just don't remember when it was turned on originally.
Okay. So you see the vehicle put its blinker on. Does it get over into the right-hand lane after that?
No,
Does it pull over to a shoulder?
no.
Where does it go?
It pulls into a left-hand turning lane, still slightly in the lane that it was in originally.
So now that you've stopped the vehicle, where are you located?
I'm located at South Monroe Street and Laura Lee.
What county is that located in?
It's in Leon County.
Now I would like to transition to after you stopped the vehicle. Were you ever able to make contact with the occupant of it?
Yes, I was.
Okay. So as you're approaching the vehicle to speak to the occupant, what type of vehicle was it?
It was a white Mercedes.
And when you approach the window, do you notice how many people are inside?
Yes,
How many?
one.
Are you familiar with who that individual was?
Yes,
Can you tell us what his name was?
Calvin Riley.
Do you see the individual that you saw driving the white Mercedes in this courtroom here today?
I do.
Okay. Could you please point him out and describe him by an article of clothing?
Yes, it's the gentleman sitting over there with a whitish shirt and glasses.
Let the record reflect that the witness has identified the defendant as the driver. Now, sir, I want to pause again. So at this point, I'm going to pause again. So when you're in your DUI training course, when you're interacting with somebody in a traffic stop like this, what specific signs of impairment are you trained to look for?
So at this point, we're just face to face. We're looking for odors. We're looking for sweat on the face. We're looking for slurred speech, confusion in the way that they're speaking. We're looking for bloodshot eyes, watery eyes, anything that kind of looks out of the normal of somebody that would be, walking down the street.
Can you tell us what the defendant appeared like to you based on your training and experience when you first made contact with him?
When I first made contact with him, before all of the conversation started, I noticed that his eyes were watery, and that they were kind of bloodshot.
Was he making eye contact with you during this?
Partially, yes.
Okay. Now, I know that you mentioned that the main reason that you stopped him was because of the headlights.
Correct.
Were you able to get his headlights on for him?
Yes.
Can you tell us what that process was like for you?
Yes. So after conversation had started, I advised him of why he was stopped because he requested the information, and I advised him that the headlights were off and he was speeding. And when I went to show him that his headlights were off, I turned the dial that's in the car that turns the lights on and off, and I turned it to auto, and the lights appeared in front of us.
So after you show him that his headlights were in fact off, did you ask for any documents from him?
Yes, before I even showed him his headlights were off, I asked for his driver's license, registration, and proof of insurance.
Was he ever able to produce those for you?
No, he was not.
Can you tell us what that was like for him looking for those documents?
Yes, so when I asked for those documents, he turned over to the center console and kind of just like hovered over it, was looking, and then he turned and opened his visor in front of him, and he was pulling papers out. Things were fumbling and falling, and he couldn't seem to find what he was looking for.
Okay. I'm going to pause for a second again.
The cross-examination tore through every word, every gesture. Viewers could feel the weight in the air, the kind of silence that comes when truth and fear share the same breath. Calvin Riley sat there, motionless. A man whose fate now depended not on the law, but on perception. And for Officer Oliver, the pressure grew unbearable. One misstep, and her badge, her reputation, and her honor could vanish. It's strange how justice can turn into theater, a stage where every blink, every pause becomes a headline.
Mentioned that he looked into a center console.
Yes.
Okay. So later in your investigation, or actually, did you notice any containers or cups near that center console later in your investigation?
Yes, there was a Tervis tumbler.
Okay. Were you able to determine what was in that Tervis tumbler?
Not the exact contents, no.
What, from your understanding, based on your observations and your training experience, what was in that?
I smelled it, and it smelled to be alcohol.
Okay. Now, Officer Oliver, during the course of this interaction with the defendant, did you have your body-worn camera on?
I did.
During the initial interaction, did you ever turn your body-worn camera off?
No, I did not.
Okay. So, would you recognize a copy of the body-worn camera if you saw it here today?
Yes, I would.
Let the record reflect that I'm showing opposing counsel what's been marked as State's Exhibit, or pre-marked as State's Exhibit A. Permission to approach?
Granted.
Ms. Oliver, I've just handed you what's been pre-marked as State's Exhibit A. Do you recognize this?
I do.
Can you tell us what it is?
This is my body-worn camera footage.
Okay. Did you have an opportunity to review the video footage on that disc?
I did.
Were you able to confirm if it's a fair and accurate copy?
Yes, it is.
Were you able to confirm if it was changed or altered in any way?
No, I was not.
The state moves into evidence what's been pre-marked as State's Exhibit A.
Any objection?
Objection, Your Honor, main sidebar.
Hours passed, questions echoed, but answers remained clouded. And as the evidence replayed again and again, people began to see not a case, but a mirror, reflecting their own doubts about truth, power, and accountability. Calvin Riley's life was dissected on public record, but so was the system that put him there.
Okay.
In that, did you say that you didn't remember your exact phrasing, but you knew from the
Objection
report?
for impeachment.
Sustained.
Amendment for Your Honor.
Yes.
Suppression hearing, that was the first time you realized your mistake.
Yes.
The defense also asked you questions about whether or not you told Officer Muth that it was open. We watched the body-worn camera footage here in court. To your recollection of it, do you recall ever hearing yourself tell Officer Muth that the bottle was open?
No.
The defense also asked you about whether or not Officer Muth searched the vehicle with you. When we watched the body-worn camera footage, could you hear her talking to you during the search of the vehicle?
Yes.
Was she also smelling the liquor in the open Tervis at the time that you were searching the vehicle?
Yes, she did.
Is it safe to say that she was helping you with the search?
Objection, leading.
Overruled.
Was she helping you with the search?
Yes, she was.
Could I have a moment to confirm?
So you may step down, but please don't leave.
Yes, sir.
So, ladies and gentlemen of the jury, I have been told that the state has at least 2 more witnesses. So we have options. It is currently 6:20. We can push through. We can break if necessary for dinner and then reconvene and try and get this case brought to a conclusion this evening, or we can use this as a natural breaking point and return on Monday morning to reconvene. I don't know if you guys would like to go back and discuss that amongst yourselves, or if you want me to just kind of go one by one and find what your feelings are. But we have to make a decision at this point of whether we're going to push forward or take a break and reconvene on Monday. I feel bad because I told you that this would be a one-day trial, and I anticipated this to be a one-day trial, and for issues that were out of my control, it has become a very long one-day trial or perhaps a 2-day trial. So would you like to go back and discuss it among yourselves? Why don't I go give you guys 5 minutes to go talk about it and then see if you can either come to a consensus, or if not, I can go one by one and talk to you about what's your preference. You may be seated. Be in recess for 5.
Thank you, Your Honor.
The courtroom fell silent. No one moved, no one spoke. It was one of those silences that carries more weight than words ever could. The judge's voice broke through it, steady, controlled. But behind the tone, there was exhaustion. Hours of testimony, countless objections, and endless rewinds of the same few seconds on a body cam. Seconds that had now become the difference between truth and a lie. When the verdict was finally announced, it wasn't just a judgment on Calvin Riley Sr. It was a judgment on everyone in that room. For Calvin, it meant freedom or condemnation. For Officer Oliver, it meant redemption or ruin. And for everyone watching, it meant confronting a truth we rarely admit out loud: that justice is not always the same as truth. The words echoed, not guilty. But the reaction wasn't relief. It was confusion, unease. People glanced at each other, unsure whether they'd just witnessed justice being served or justice slipping quietly through their fingers. In that moment, you could feel it, a strange tension hanging in the air, like the aftermath of a storm that never truly passed. Calvin sat still, his eyes fixed on the table before him. No celebration, no smile, just stillness. Because even in victory, he knew something sacred had been broken. And across the room, Officer Kirsten Oliver's gaze fell to the floor. Her hands trembled, just slightly, not from fear, but from the weight of everything that had just collapsed around her. The world outside would soon turn this case into headlines, thumbnails, and hashtags. Another cop caught lying. Justice served at last. Florida officer accused of tampering evidence. But none of those words captured the reality that played out inside that courtroom. Because this wasn't just about a bottle moved a few inches on the ground. It was about something deeper, something that reaches into the core of how we see justice itself. It was about how fragile truth becomes when power gets comfortable. For the defense, the victory was a warning. For the prosecution, it was a scar. And for the public, it was a reminder that corruption doesn't always wear a mask sometimes. It wears a uniform, a smile, and a badge of honor. Yet maybe that's too simple. Maybe it wasn't corruption at all. Maybe it was something even more human. A mistake, a moment of panic, a split-second decision made under the crushing pressure of perception. Because when the spotlight turns on, people don't always act like heroes. That's the tragedy of this case. Everyone lost something that day. Calvin lost his peace of mind. Officer Oliver lost her credibility. And the system, the very foundation of law and order, lost another piece of the public's faith. They say justice is blind, but maybe that's the problem. Because sometimes we need it to see the flaws, the cracks, the manipulation that hides behind procedure. Justice can't exist in darkness. It only survives when the truth is allowed to breathe.